No, that case is not. That case is not. Original has been filed in which case, Mr. Lama?
My lords, for the first, that is tax appeal 18, it has been filed in tax appeal 14. And for my lords, the next items, the original has been filed in tax appeal 21.
I see, ma'am. So for it, let tax appeal number 14 of 2020 be listed along with these appeals.
Much obliged.
Item 7. Tax appeal number 75 of 2020. Mr. Manoj Tandon for the update.
May I please, Mr. I am appearing for the appellant. The defect pointed out by the office is that I should enclose the decree in the present appeal. For this adjournment was also granted because I took time to advise the learned lawyer to apply and get. But he is not able to get any decree. He says that it has not been prepared.
You should have stated that on affidavit. On that basis, we would have asked the concerned family court to prepare the decree and issue it if it has not been issued. Otherwise, only oral submission we cannot issue such direction.
Yes, I understand. I will do that.
The counsel for the appellant, Mr. Manoj Tandon, seeks and is allowed 1 week time to file a supplementary affidavit.
Ma'am.
List it after 1 week.
Ma'am.
Item number 8. Article number 81, 2020. Mr. Abdul Kalam Rasidi for the appellant. Mr. Rasidi, you have not filed the second set.
My lord, it is mistaken in my office, my lord. So one time, as a last chance, may be given. Limitation petition नहीं फाइल हुआ है जो.
Week time is allowed to the counsel for the appellant to file the second set of the IA number 5806 of 2020 seeking condonation of delays. शीशा भी हटवाइए. तब तक इस बीच में हट जाए किसी ये वाला खंड है और ये हट जाए. ये एक और डिफेक्ट है मिस्टर रसीदी, वो भी रिमूव कर दीजिएगा. He undertakes to remove the surviving defect number 5, also within the same time. बता दीजिएगा, लगता है क्विट कर गए. Item 9, article number 86 of 2020, Mr. Ajay Kumar Singh of Jharkhand. Price time has been granted to the learned counsel for appellant to remove the surviving defects. Lastly, by order dated 5th January 2022, but defects number 1, 2, 4 and 5 pointed out in the order in the previous order has not yet been removed. So, by way of last indulgence, further 2 weeks time is allowed to learn counsel for appellant to remove this defects. Item 10, WPT number 2524 of 2020, Mr. P. Kudar for the petitioner. Mr. Sati Kumar, Mr. P. S. Pati, all the respondents.
Lordship, in this matter, Lordship, type copy required to be filed to may allow 1 week time, Lordship. Will file type copy in this matter.
1 week.
Yes, Lordship.
1 week time. Remaining defect.
Same prayer for Lordship. Item number 11.
Same order. Other side, Mrs. Ranjana Mukherjee. Anyone else also? No.
And for
Okay. Surabhi 82, 82.
Lordship, I am appearing for GS for state here. Okay. On behalf of Mr. P.S. Pati, because he is on in some other court. So I am just appearing. He state appear on behalf.
So, but Mr. Deepak Kumar, where is he? Defect number 1. The revision application number has not been mentioned. Surviving defect indicated in the order dated 28th September 21 has not been removed. Till date, by way of last indulgence, 1 week time.
Okay.
WPT number 5315 of 2021, Mr. Sunil Gloria for the petitioner. Mr. Ashok Kumar Yadav for the respondent.
May it please your lordships. Your lordships, I pray for 2 weeks' time for removal of defects. There are 4 defects, your lordship.
3 weeks.
2 weeks, your lordship.
2 weeks time.
Much
Item 40, WPT number 23 of 2020, 22. Mr. Salona Mittal for the petitioner, Mr. Rajiv Sinha, Mr. P.S. Pati for the respondent.
My lords, there are 3 defects which have been pointed out. The first is that the year of the case number mentioned in the presentation form may be corrected. Because initially, whenever in the first week, always it happens that instead of 22, 21 is typed. So this, my lords, either it may be ignored or the office can correct it, my lords. The second is PO and PS may be mentioned in the details of respondent number 3. Now, since respondent number 3 has already taken notice, basically PO and PS is mentioned for the purpose of issuance of notice. But since Mr. Pati is already appearing for respondent number 3, that defect may also be ignored. So for the defect number 3 is concerned, that certain pages may be tagged in proper direction. Because what happened when we had e-filed this petition, we had given this petition, these pages in a horizontal manner. Maybe when the office took out the printout and they tagged it in a vertical manner, so the office can be directed to tag it properly, Milos, in a horizontal manner instead of a vertical manner.
You have filed the hard copy also.
No, I have not filed the hard copy.
So filing of hard copy is also a requirement whenever you file it through mail.
No, it's not required anymore. We don't file it anymore. Initially, we used to file it in 2020, April, May, when the courts started. But now it is no more a requirement to file a hard copy.
No.
If the court says, obviously I'll file it. There's no difficulty. I can file it if the court wants. But nowadays, we don't file it at all.
No, that rule has not been relaxed or waived. That continues. In fact, there is a talk going on because of e-filing in Supreme Court also. Perhaps the requirement of filing hard copy was there, but the lawyers have raised an issue that it becomes a double exercise. But so long it has not been.
In one of the cases, the objection was that few pages are faint, so you file a hard copy. Now, when we file the hard copy, again a fresh set of objections by the office, over and above what was pointed out earlier. So that would also be a problem, that the defects pointed out once when we file the soft copy, and further the defects will be pointed out again when we file the hard copy. So that issue would be there.
May I indicate, my lord, Your Lordship?
Yes, Mr. Garodia. Let me tell you, for me, these days my mind stops working when the issue of defect removal is there. It's such a painful exercise to find out which defect, because these things are basically of the Lavajima and the Registrar General.
And Milos, in any view of the matter, I
Straight
had
away
filed it
coming
much
to
earlier.
the bench.
I, I had filed it much earlier. If the court would have, if the office would have sent it for inspection, for defect removal, I could have. These are very petty things which I could have removed. Very petty things.
True.
So
Not
what I was
blaming
saying
you.
was,
Our mind stops working on defect removal. So,
I know.
yes, Mr. Garodia, you wanted to.
My lord, by Your Lordship, my lord, what my learned seniors indicated regarding filing of hard copy, my lord, in fact, on first, my lord, I had pointed out to the Honorable Chief Justice, in Jharkhand, my lord, we are filing online through email. There's a designated email of the court which has been notified and we file it through the email. So there is a requirement of filing of hard copy. We are filing hard copies after the cases are numbered in each and every case, because we give an undertaking that we file an hard copy. What is happening, my lord, here we have not adopted the NIC portal. The NIC portal by which the filing is done, the moment the filing is done, my lord, a diary number or a filing number is generated. In that, there is no requirement of filing a hard copy. That itself is a filing. In
No.
the eye
Here
of
also, when we file the diary number is the numbers are generated on the filing of soft copies. We
no.
file the.
That filing number which is generated is the files are downloaded from the online from the email, and then it is registered in the separately in the portal by the office, and then the filing number is given after 3 hours, 4 hours, 2 hours, whatever is the case may be. But now the Honorable Chief Justice has instructed the CPC that now filing will take place through NIC portal itself, and that instruction has already been given, of course, in the court. Formal instructions may be in the administrative order, and thereafter, when we file it through NIC portal, then there would be no requirement of filing of hard copies.
Because filing of hard copy would be a full exercise. The
Just
purpose of
wanted to both all of
filing the hard copy,
whether,
I don't know the purpose of filing the soft.
whether the filing which you both of you are talking about, is it an email filing or an e-filing under the e-filing rules?
Yes, my lord, it is the email filing. All these are email filings happening in Jharkhand.
No, that doesn't help. No? When the e-filing rules have been notified, I understand initially there might be hiccups, but council should, their officers should try and e-file those. Then it becomes easier.
That e-filing, my lord, that was only pointed out, and there's some the functionality, my lord, it is not started properly. So, my lord, the CPC was directed to join, and that filing, e-filing, will now be through the NIC portal, which your lordships are indicating, which the rules have already been notified.
Ah,
Yes.
so that would be the proper filing. No? That kind of filing is such which a paperless court can also access, and the councils can also argue from their respective screens and point out things like that. All advanced features of that e-filing.
With bookmarks.
So,
With bookmarks.
With bookmarks, my lord, Supreme Court doesn't take bookmarks, but several High Court takes bookmarks.
okay.
It will
So,
take, but I think by the time we start all this, the courts may start physically in maybe 2 to 3 weeks time, because
but
this
that
time the
doesn't. No, Mr. Mittal, the vision document is such on which the judiciary is working under the Honorable E-Committee of Supreme Court, that these digital methods of functioning of the court are only going to be more and more efficient and in vogue.
that will be
That
the
doesn't
future.
mean that physical appearance or physical argument is going to be done away with, but just to
Yes.
make everything very digitized. So the 3.0 um, software that was launched, of course, it has not been fully implemented. In that, there is a provision that even a person can swear an oath also electronically. He doesn't have to come.
Oh.
So these things will be there, in fact. And But as of now, since it's an email filing, Mr. Mittal, you file the hard copy.
I'll file it tomorrow. By tomorrow, positively, it shall be filed.
So we will only indicate that while filing the hard copy, you will remove the surviving defects.
And that I will do. But in the meantime, if I may indicate the issue, Mr. Pati can.
We have not applied ourselves on the issue. Let it come. Once you file it, let it come as early as possible.
What I request that I'll file it
Yes.
tomorrow. Let it be listed on Thursday. I'll file it tomorrow.
Next week it will come.
Okay,
File
next
it
Monday.
tomorrow.
Next Monday.
Then senior counsel for the petitioner, Mr. M.S. Mittal, submits that the hard copy of the pleadings would be filed by tomorrow.
Yes.
And surviving defects, as pointed out in the email filing, shall also be removed. So, if the defects are removed and the hard copy is filed, let the same be listed under appropriate heading. And let the case be listed under appropriate heading in the next week.
Date will be given Monday or Tuesday, whenever.
It will come, the court master will arrange it.
Oh, very good.
Obliged.
For others, item 15, case number 33 of 2019, Mr. Rahul number for the police appeal. Mr. Sunil Gavri,
Malaj, there is an IA for condonation of delay, Malaj, of 31 days, Malaj. The reasons are explained in paragraph 3, Malaj. I was saying if the
Service of notice is complete.
Malaj, they are appearing, Malaj. Respondents are appearing, Malaj.
Your Lordship, I am appearing for the respondents.
Okay, very good. And
Malaj,
what is the
Malaj, there is
tax
an
effect of the
Malaj.
what is the tax?
Tax of this case is only
Malaj, that is the next IA, the counter IA by the respondents, Malaj. So I was praying that the limitation be condoned, and as far as their IA of the tax effect being less than the prescribed limit, Malaj, I'll have to take instruction if the case falls in any of the exceptions, Malaj. So I'll take 2 weeks time, and I'll come back on this, Malaj. The only thing I need to confirm from the department is whether this falls in any of the exceptions. Undoubtedly, Malaj, the tax effect is less than the prescribed limit.
Yes.
you
So-
seek instruction.
Will condone the delay?
Malaj. That IA can be disclosed.
On hearing the learned counsel for the parties, after going through the reasons explained in the IA number 881 of 2021, seeking condonation of delay of 29 days in preferring the instant memo of appeal, the delay is condoned. Stop. IA stands disposed of. Then counsel for the appellant revenue seeks time to obtain instruction on IA number 4221 of 2021 as to the tax effect of the impugned order.
Malaj.
That is listed out. Under appropriate heading.
Much obliged.
Your Lordship.
item press file admission, item 16 number 840 2020, along with action number 21. Mr. P. Sada for the
Yes, my lord. By Annexure 2, my lord, the state government through Commercial Taxes Department is demanding electricity duty from me on the basis of Jharkhand Amendment Act 2011. And my lord, the petitioner is a consumer of electricity and purchasing electricity from JVVNL Annexure Respondent number 4 with respect to its township area. And JVNL is the licensee.
Who is appearing for JBBNL?
My lord, we had already served the copy upon the advocate of Mr. Ajit Kumar appearing at that time when we filed the writ petitions. And under the similar circumstances, my lord,
Who is appearing for JBBNL? Name of
actually when we
इनका नाम अपेयर कर रहा है JBBNL की तरफ।
मिस्टर अजीत कुमार का नाम अपेयर हो रहा है।
अब नहीं है
मिस्टर राजीव रंजन मस्ट बी एडवोकेट जनरल।
जी जी जी, इसमें इंस्ट्रक्शन जो लेते हैं, क्योंकि इसमें स्टेट भी पार्टी है, जीयूएनएल के तरफ से भी सीनियर एडवोकेट मिस्टर राजीव रंजन अपेयर करते हैं जो।
नहीं तो अभी तो the challenge is to the electricity duty laid by the commercial taxes department. So you are in contesting respondent, but JPBNL is also a necessary party and already on record. So we will have to find out from whether what is the relationship first between the SST, the petitioner and the JBBNL, whether they are bulk suppliers, whether they are paying electricity duty, whether any employee inspection, things like that.
Yes, my lord. I pray some time, my lord. Next week.
My lord, so many similar writ applications have been filed, and my lord has been passing interim order also, my lord. Yesterday,
interim order was passed by our previous bench in one case in which Mr. Mittal was appearing. That was a commercial. 2012 rules, the commercial has been taken out of that. Second was the petitioner, and that is a commercial connection. So therefore, we were inclined to grant stay.
My lord, as per the judgment rendered by this honorable court, the sine qua non is that some part of electricity obtained by a person from JVNL or from whatever source it may be, at least some part must be sold. And admittedly, my lord, I'm not selling any part of electricity obtained from JVNL. Under these circumstances, this honorable court has interpreted and said that unless some part is being sold, no liability is upon the person. The liability is upon the supplier, either DVC or JVNL or whoever it may be. Therefore, my lord, this case is fully covered by the judgment rendered by this honorable court in the case of Ananjaya fuel. And so far bulk supply is concerned, my lord, that has also been considered by this honorable court at paragraph 36 of the judgment, my lord. I may be permitted to refer to paragraph 36. Even if I am a bulk purchaser, then also I am not liable. That is what my lord.
Shop enterprises is a matter where your lordships have discussed about bulk supply and finally allowed the writ petition. Shop enterprises is the name of the case. I'll send the number of the case, but the name is Shop Enterprises.
We have that order.
Yes.
We have that order, yes. Shop enterprises.
That's finally decided in our favor.
तो 2012 रूल्स के लाइट में वो हम लोगों ने डिसाइड किया ना।
Yes.
तो उसमें कमर्शियल was taken out of.
Yes.
Here it's a different case. case. Na? Here it's a mining unit, BCL.
My lord.
So,
But my lord, Anjaya has dealt with everything. Even if
no,
it is a bulk purchaser, then also, my lord, unless it is shown that some part of electricity obtained is being sold by the petitioner, no liability is upon the petitioner. Neither it is assessing nor duties payable directly to the state government through commercial taxes department. This is what has been held by this honorable court. My lord, kindly allow me to permit me to refer to paragraph 36 of the judgment rendered by.
Mr. Poddar, we have also read that judgment and we have applied our mind to similar issue very recently also. But JBVNL is an important party which you have made. We want to hear their version. Whatever you are saying, that you are not selling it is a question of fact. And question of fact, unrebutted, not replied by Commercial Taxes Department, JBVNL may have to say something. And if it is a question of fact, then the issue will arise whether appeal would be the right remedy. So let JBVNL appear.
Has been passed, my lord. First of all, then I say on what basis? Then thereafter, admittedly, they passed the assessment order. Thereafter, an ex parte order has been passed. Therefore, question of filing of appeal doesn't arise, my lord. In view of a Whirlpool Corporation case, my lord. Violation of natural justice and equity, my lord.
They have
that is different from an exception in entire order sheet. उसमें हम लोग खुद एडमिट किए हैं। ठीक है, उनको जवाब देने दीजिए, JBNL को कोई अभी देने दीजिए जवाब।
मिस्टर मोहन दुबे,
यस माय लॉर्ड।
तो आप बताइए फिर JBNL के तरफ से कौन अपीयर करेंगे? एडवोकेट जनरल के ऑफिस से तो कमर्शियल टैक्सेस डिपार्टमेंट में रिप्रेजेंट होगा।
जी जी, जो इसमें बहुत सारे पैनल जो हम अभी पूछ लेते हैं, जो 2-3 केस के लिए पास ओवर कर दिया जाए, अदरवाइज इसमें मनोज कुमार या सचिन कुमार है जो पूछ लेते हैं इसमें। जो
ये मिस्टर मनोज टंडन का नाम जो अपीयर कर रहा है, ये किनके तरफ से?
वो भी बिजली डिपार्टमेंट में पहले पैनल थे जो
ये फाइल हुआ 2020 में फाइल
जी।
अब पूछ के बताइए ताकि हम लोग उनका नाम इंडिकेट कर दें और वो नेक्स्ट डेट को फिर
जी तुरंत हम एक केस के लिए जो हम तुरंत
उनको अपीयर कराइए, उनको टाइम दे देंगे काउंटर फाइट करने का।
जी जी, हम अपीयर कराते हैं।
पास ओवर। उसके बाद रिमांड कर दी, एग्जामिन कर लीजिए, किसी और प्रोविजन में भी इनका ये भी हो सकता है। सिर्फ कॉपीज का 2 सेट रखिए गए हैं, तो बार बार इसका जरूरत पड़ेगा। ठीक साहब, यस, नेक्स्ट आइटम।
Item 22, WPT number 2981 of 2021, Ms. Amrita Sinha for the petitioner, Mr. PS for the.
Your Lordship, in this case, I have challenged the show cause notice as well as the ex parte order dated 28/9/2020, against which it has been alleged that I have been dealing with a non-existing dealer and my ITC was asked to be reversed and penalty and interest has been charged. Counter has been filed by the department, Your Lordship. I need to file the rejoinder to these counter.
Mr. Mitchell.
Yes, my lord.
You have not taken the plea of alternative remedy in your counter affidavit?
My lords, we have para 6, my lords. I am appearing in 23 and 24, my lords. Seal number 23 and 24. We have taken the plea, my lords, of alternate remedy in para 6.
In item 22, I did not find that plea.
Like, I'm not aware of 22, my lords. I haven't seen the counter, my lords. In 23 and 24, it is certainly there.
Mr. Pati, you are appearing in 22.
My lords, he had requested me to appear, my lords, but I don't have the pleadings. Probably in his matters also, my lords, but the plea of alternate remedy, my lords, is always there, my lords. It's a question of law, even in 23 and 25.
He has taken in para 11. So,
May I
Ms.
submit?
Amrita, yes, yes.
The plea of alternative remedy, I won't deny that there is, but the manner in which it is not the first case, Your Lordship. There, I have filed at least 10 to 20 cases against an ex-party order. This is the manner in which the department is proceeding in every other alternative matters, Your Lordship. And this has to be bring an end, because I just want to show page 88 of the impugn order, the manner in which they are dealing with, and there is always a discretionary jurisdiction with the Honorable Court, Your Lordship, in the writ petition to deal with if the principle of natural justice has not been complied with. I just like to show page 88 once, Your Lordship, of the first, my serial number 22. The manner in which they are doing on the same very identical issues, they are for the past transaction they are entering, they are asking us to reverse the ITC, they are imposing the interest, they are imposing penalty without giving any opportunity, without considering the papers on record, and things are being done. And in the alternative remedy, the appeal, which is the we have to deposit a pre-deposit amount. So just in order for that purposes, they are doing this.
My lords, I strongly object, my lords, to these comments. It cannot be that a pre-deposit is an onerous condition, my lords.
May kindly be seen the act of the department, may kindly be, it is evident from page 88, Your Lordship.
Now, one thing which I wanted to be clarified on facts before we proceed. In the writ petition, you have stated about some Sri Sai Enterprises.
Yes, Your
In
Lordship.
the counter affidavit, the respondents are stating about some Ma Kali Enterprises.
Yes, Your Lordship, that is wrong, which they have stated there. Actually, two cases are there of the same party. One is of Sai Enterprises, wherein one party, their non-existing party Sai, and in the other matter, Ma Kali is there. However, in their counter affidavit, they have done it wrong, Your Lordship. That I have also. There is an error in the counter affidavit, Your Lordship, with respect to that.
So, how do you say that principles of natural justice have not, or the so-called notice has not been issued and followed?
The show cause notice was issued, Your Lordship. I submitted my explanation. That was not considered. Opportunity of hearing was not given to me. Any personal opportunity of hearing should have been given to us. In the just writing a single line that we are not satisfied, and they are passing the impugn order without even passing a reason order. That's what I want to show, Your Lordship, from page 88 itself. Just a single line that we are not satisfied and they are imposing the tax. Even they are not giving the reasoning for that. Mere on the direction of the higher authorities, they are doing the entire thing. Page 88 may kindly be seen, Your Lordship, once.
Yes.
Page 88, I would like to show Prasangik SCN के विरुद्ध. Para 6. प्रासंगिक एससीएन के विरुद्ध मिसेस सत्यम इंटरप्राइजेस के द्वारा स्पष्टीकरण समर्पित किया गया है एवं उक्त के माध्यम से विवादित आईटीसी को अपने मामले में अनुमान्य होने का दावा किया गया है। उनके द्वारा समर्पित स्पष्टीकरण दावे के सम्यक जांच की गई एवं पाया गया कि व्यवसायी विवादित आईटीसी को जीएसटी की धारा 16(2)(c) के विरुद्ध के द्वारा विहित शर्तों के अधीन अपने मामले के अनुमान्य होना साबित नहीं कर सके। जीएसटी अधिनियम की धारा 155 के अनुसार इतना को अनुमान्य को साबित करना करते व्यक्ति से विदित अपेक्षित है। करती व्यक्ति वर्तमान मामले में अपनी आईटीसी की अनुमान्यता को साबित करने में असफल रहे। इस प्रकार एंड दे हैव imposed the penalty.
You read the entire order.
Yes, Your Lordship, the entire order I can. The entire order, if read, these are all the contents which were raised in the show cause notice. Identical things have been stated over herein. And when I submitted that, how the tax in para 5, it is important, Your Lordship, what allegation they are imposing upon us. The allegation which they are imposing on the basis that may kindly be seen merely on the presumption they are stating these things. May I just read para 5 or from the starting page I should read?
Start itself.
I will be reading from the starting itself, Your Lordship, page 86. मुख्यालय के समय समय पर भेजे गए इंटेलिजेंस नोट के आधार पर अंचलों प्रमंडलों द्वारा किए गए निरीक्षण कार्रवाई के फलस्वरूप कई कर दे व्यक्ति अस्तित्व विहीन पाए गए, जबकि उनके द्वारा GSTR 1 दाखिल कर अन्य कर दे व्यक्तियों को इनपुट टैक्स क्रेडिट का लाभ पहुंचाया गया है। ऐसे अस्तित्व विहीन कर दे व्यक्तियों के फॉरवर्ड ट्रांजैक्शन को संकलित करते हुए विशेष सचिव वाणिज्य कर विभाग झारखंड रांची के प्रसंगित पत्र के माध्यम से प्राप्त करने के साथ साथ निर्देशित दिया गया है कि अस्तित्व विहीन कर दे व्यक्तियों के उक्त फॉरवर्ड ट्रांजैक्शन के आधार पर इनपुट टैक्स क्रेडिट का लाभ प्राप्त करने वाले कर दे व्यक्तियों पर नियमानुसार कार्रवाई की जाए एवं जांचोपरांत रॉन्गली अवेल ITC को ब्याज सहित रिवर्स करने की कार्यवाही की जाए. So in this paragraph they are stating your lordship that only GSTR 1 was filed by the dealers and thereafter they are transferring the ITC and thereafter no step has been taken. उपयुक्त कंडिका में चर्चित पत्र के साथ संलग्न सूची में मिस्टर सत्यम इंटरप्राइजेस GST नंबर सो एंड सो का नाम अस्तित्व विहीन सत्यम इंटरप्राइजेस द पिटिशनर अस्तित्व विहीन कर दे व्यक्ति श्री साई इंटरप्राइजेस GST नंबर सो एंड सो के GSTR 1 के द्वारा अग्रसित ITC के लाभार्थी के रूप में अंकित है, अतः वर्तमान कार्यवाही का आरंभ अपेक्षित हुआ. मिस्टर सत्यम इंटरप्राइजेस GST नंबर सो एंड सो ने निम्न विवरणी अनुसार अस्तित्व विहीन कर दे व्यक्ति श्री साई इंटरप्राइजेस GST नंबर सो एंड सो से इनपुट टैक्स क्रेडिट प्राप्त किए. Now these are the we have entered into a transaction in the month of November 2017 against which tax invoice number is also there, your lordship. It is written in the third column tax invoice. I have annexed the tax invoices number. The date of the tax invoices is 4th of November 2017, the taxable value, and the total ITC claim is 3,43,316.16 paise. Now further they are stating eligibility and condition for taking input tax credit. Section 16. Every registered person shall subject to the condition and restriction as may be prescribed. This is not important, lordship. 2. Subsection 2 is important. Notwithstanding anything contained in this section, no registered person shall be entitled to take credit of any input tax in respect of any supply of goods or services or both to him unless he is in possession of the tax invoices. We are in the possession of the tax invoices. We have duly annexed the tax invoices. Or debit note, we have even given the tax invoices copies. Debit note issued by a supplier registered under this act or such other tax paying document as may be prescribed. He has received the goods or services. We have duly received the goods. There is no such allegation that we have not received the goods. Explanation: for the purpose of this clause, it shall be deemed that the registered person has received the goods or, as the case may be, services. Number 1, where the goods are delivered by the supplier to a recipient or any other person on the direction of such registered person, whether acting as an agent or otherwise, before or during movement of goods, either by way of transfer of goods or title of the goods or otherwise. Number point 2, where the services are provided by the supplier to any person on the direction of and on account of such registered person. Now C is important, upon which they are emphasizing, your lordship. Subject to the provision of section 41 or section 43A, the tax charge in respect of such supply has been actually paid to the government, either in cash or through utilization of input tax credit, either in cash or through utilization of input tax credit admissible in respect of the said supply. So what the allegation is that the person who has supplied the goods, they have not actually paid to the government. This is the only allegation. Now I'm reading further, your lordship, para 5. विदित हो कि वर्तमान कार्यवाही अंतर्गत अस्तित्व विहीन कर दे व्यक्ति के द्वारा अग्रसारित पास ऑन किए गए ITC की जांच की जा रही है, अतः सर्वप्रथम अति महत्वपूर्ण शर्त 16(2)C के अनुपालन की जांच की गई एवं पाया गया कि आपूर्तिकर्ता मेसर्स श्री साई इंटरप्राइजेज अस्तित्व विहीन है एवं उनके द्वारा फ्रॉडुलेंट मेथड से ITC को क्लेम अवेल पास ऑन किया गया है. उक्त अस्त विहीन आपूर्तिकर्ता ने जीएसटीआर 1 दाखिल किया है. The supplier has filed the GSTR 1. GSTR 1 contains the detail of the person to whom the supply is being made and the tax which has been paid by them. एवं उक्त के माध्यम से श्री साई इंटरप्राइजेस को आईटीसी पास ऑन भी किया है. साथ ही जीएसटीआर 1 के अनुसार दे करके भुगतान को जीएसटीआर 3B रिटर्न में दर्शित किया गया. They have even filed the GSTR 3B, that is the return. They have filed the GSTR 1, they have also filed the GSTR 3B, and once GSTR 3B is filed, your lordship, it is only filed upon payment of tax. Otherwise, the section itself says that when tax has to be paid, the last day when the return is to be filed, on that particular moment itself, the tax has to be paid. And in this case, they are admitting that
No, not necessary.
no, your lordship, there is a provision. I may be permitted to show that provision itself, your lordship. The provision is there wherein the tax and the manner in which they are saying, your lordship. And further, if your lordship is permitted,
Only if a person filing a GST 3B doesn't pay the tax, then only the question of penalty and interest arises upon him.
if I read the further line, your lordship, the further line itself says that they have paid the tax. That may be permitted to be read, your lordship.
Yes, read that.
यस अनुसार कर दे भुगतान को जीएसटीआर 3B में दर्शित किया गया है, किंतु जीएसटीआर 3B में दर्शित किया गया समस्त भुगतान आईटीसी का उपयोग करके किया गया. बिकॉज आई हैव पेड द इंटायर, नॉट आई बट द सप्लायर हैज पेड द इंटायर, हैज यूटिलाइज्ड हिज इंटायर आईटीसी इन द पेमेंट ऑफ टैक्स, देयरफॉर दे आर प्रिज्यूमिंग द टैक्स हैज नॉट बीन पेड. मैं फिर से आई एम रीडिंग इट अगेन योर लॉर्डशिप. किंतु जीएसटीआर 3B में दर्शित किया गया समस्त भुगतान, all the payment which he has to done, ITC का उपयोग करके किया गया, because they have utilized their entire ITC. चूंकि कर दे आपूर्तिकर्ता अस्तित्व विहीन है एवं उनके क्रेडिट लेजर में संचित आईटीसी जांच में अनुमान्य पाया गया है, अतः अन्य अनुमान्य आईटीसी का प्रयोग करते हुए किया गया भुगतान वास्तविक एक्चुअल नहीं हो सकता है. दिस इज मेयरली अ प्रिजम्पशन कि एक्चुअल नहीं हो सकता है. And one thing I like to point out at this stage, your lordship, when their registration was cancelled, I have brought that document on record itself that their registration was cancelled in the year January 2021 itself. And I entered on for the reason why it was cancelled merely for the reason because since 2019, since January 2020, they were not filing their returns and therefore their registration was cancelled in the year 2021. So it became non-existing, even if it is presumed that it was not, it became non-existing only after 29th of January 2021. I entered into a transaction in the month of November 2017 and his registration was why it was cancelled because for the 6 continuous month he has not filed his return. Therefore, your lordship, he is continuously filing his, even as per the government record, your lordship, their own data, which I would like to show, they are stating that they are continuously filing their returns till December 2019. And hence, thereafter, they are not filing the return and therefore their registration has been cancelled. So, any subsequent thing, they have not filed the registration after January 2020. How can it be said that it was not in existence in the year 2017? And when they have himself admitting that the GSTR 1 was filed, GSTR 3B was filed, the invoices copies are there, the delivery has taken place, everything they are admitting, just on assumption and presumption कि ये actual नहीं होता है.
Read further.
जी. इस प्रकार मिसेस साई इंटरप्राइजेस ने अस्तित्व विहीन कर दे व्यक्ति श्री साई इंटरप्राइजेस से जो भी आपूर्ति प्राप्त किया है उसके विरुद्ध मिसेस साई इंटरप्राइजेस के द्वारा सरकार को कर का भुगतान वास्तविक रूप में किया जाना स्थापित नहीं होता है. कंडीशन 16 सबसेक्शन 2C इज नॉट सैटिस्फाइड. उपर्युक्त तथ्यों के आलोक में श्री साई इंटरप्राइजेस के द्वारा निम्न विवरणी अनुसार इनपुट टैक्स क्रेडिट के ब्याज सहित रिवर्सल किया जाना निर्धारित किया गया. एंड योर लॉर्डशिप, दिस इज इंपॉर्टेंट अंडर सेक्शन 73 सबसेक्शन 1. 73 सबसेक्शन 1 doesn't deal with the fraudulent practice. Section 74 deals with the fraudulent practice. So they are admitting that no fraud has been committed on our part, because at the time when we entered into transaction, it was duly there in existence, and therefore they have not levied interest, or show cause was not issued under Section 74. It has been issued under Section 73, and the order has also been passed under Section 73 of the Act. So there is no such allegation of fraudulent practice or something like that. Now, skipping the टेबुलर फॉर्म, उपयुक्त कार्यवाही के संबंध में जांचोपरांत जांचाधीन कर दे व्यक्ति मिसेस सत्यम इंटरप्राइजेस को धारा 73(5), सो धारा 73(5) एवं नियम 142(1)(a) के प्रावधान अनुसार इंटीमेशन रेफरेंस नंबर 55 डेटेड 29 फरवरी 2020 निर्गत प्रेषित किया गया था। उक्त के विरुद्ध व्यवसायी ने अपना कोई स्पष्टीकरण समर्पित नहीं किया, अतः नियमानुसार धारा 73(1) के नियम 142(1) के द्वारा विहित प्रावधान अनुसार संदर्भित कारण परीक्षा नोटिस शो कॉज नोटिस के माध्यम से पुनः परीक्षा किया गया कि क्यों नहीं उपयुक्त अनुसार कर दे व्यक्ति के विरुद्ध ब्याज सहित आईटीसी के रिवर्सल का आदेश पारित किया जाए। एससीएन प्राप्ति के 30 दिनों के अंदर कर दे व्यक्ति को स्पष्टीकरण समर्पित करने, निर्धारित ब्याज सहित आईटीसी का रिवर्सल करने हेतु निर्देश किया गया। प्रासंगिक शो कॉज नोटिस के विरुद्ध मिसेस साई इंटरप्राइजेस के द्वारा स्पष्टीकरण समर्पित किया गया। वी हैव एनेक्स entire document, the GSTR1, GSTR3B, when his registration was cancelled, our tax invoices, we have payment the tax, everything. एवं उपयुक्त के माध्यम से विवादित आईटीसी को अपने मामले में अनुमान्य होने का दावा किया गया। उनके द्वारा समर्पित स्पष्टीकरण दावे के सम्यक जांच की गई एवं पाया गया कि व्यवसायी विवादित आईटीसी को जीएसटी की धारा 16(2)(c) के द्वारा विहित शर्तों के अधीन अपने मामले में अनुमान्य होना साबित नहीं कर सके। How we are not even to satisfy that reason has not been given. जीएसटी अधिनियम की धारा 155 के अनुसार 155 deals with the burden of proof, your lordship, that one have to discharge this burden of proof that they have paid the ITC and all the documents we have duly annexed के अनुसार आईटीसी की अनुमान्यता को साबित करना कर दे व्यक्ति से विहित अपेक्षित है। कर दे व्यक्ति वर्तमान मामले में अपनी आईटीसी के अनुमानता को साबित करने में असफल रहे। If they would have wanted some other document, they could have asked for it, because we, as per our understanding, have annexed all the documents. इस प्रकार उपयुक्त के
after reading of this impugned order, two things are clear. That there was a show cause notice upon you, you represented, you made your reply to the show cause notice, you have annexed certain documents, and they have applied their mind, they have not believed your reply and disallowed the ITC and imposed the penalty and interest, etc. Now, all these facts, whether you had produced the invoice corresponds to the tax paid by you to the seller. These things are inquiries on fact which an appellate authority is equipped to deal with.
For that purpose, I would just request that let the matter be remanded back to the assessing officer. Let the matter be remanded back itself to the assessing officer. Let him again examine the entire document, your lordship, which was there.
That would amount to sitting as an appellate authority and examining the reasons and all the intentions of the parties. Why is 107 otherwise? Whatever you are arguing, you see, we can follow that the reason for disallowing ITC against you is that the seller from which you have received the goods, they have not paid the tax. ITC availed by them was disallowed, declared to be invalid. Actual cash was not paid by them. The state exchequer has not received the tax amount. And against that tax amount, the ITC was availed by you. So they are saying that under 16(2)(c), the ITC availed is invalid. and therefore they gave you an opportunity, you gave your reply, you gave your proof of payment of tax through the invoices, etc. Whatever it is, these things are to be looked into by the appellate authority. No? How do we usurp the function of the appellate authority and go on
The
examining
appellate
whether your
authority will
invoice?
back the matter to the assessing authority, Your Lordship, because this is not the single incident, Your Lordship, and they
The
are
incident
admitting that against my ITC, I have paid my discharge my output tax liability. Just one judgment I would like to show of the Honorable Court, Your Lordship. That judgment, although I have not sent it because I thought of filing the rejoinder, but that part I have also the judgment I have mentioned in my writ petition itself, Your Lordship. In the same and similar circumstances wherein the Honorable High Court has pleased to entertain the writ petition and remanded back the matter to the assessing authority itself. That is page 40 of my page 40. I have not just forwarded this judgment, Your Lordship. Page 40 of my writ petition may kindly be seen, Your Lordship. I have quoted that judgment. May I read it, Your Lordship? Page 40, para 50.
Yes, yes.
The Honorable Chhattisgarh High Court on 22nd 10 2019 in the case between Daiichi Iron and Steel Private Limited versus Chhattisgarh GST Commissioner and reported in so and so has held as under, whereby the respondent have blocked the operation of the credit account of for availing the input tax credit so far as the petitioner establishment is concerned, that the only ground for blocking the credit account of the petitioner is that the petitioner has been doing business with a non-existing entity, that is Mrs. Jai Bharat Enterprises, which has a GST number so and so. In our case also GST number was duly given to the Sai Enterprises. The petitioner drew the attention to this court to certain information which has been downloaded by the petitioner for the portal of the respondent themselves, which shows that the said Mrs. Jai Bharat Enterprises is a registered body under the respondent and is paying tax also to the respondents. Therefore, the issuance of annexure P1 is contrary to their own record. This court is of the opinion that no fruitful purpose would be served in keeping the writ petition pending. Rather, end of justice would meet if the writ petition is disposed of with a direction to the petitioner to file a representation oblique objection before the respondent number 2 in respect of the contention that it has raised in the present writ petition, particularly in respect of the existence of Messrs. Jai Bharat Enterprises within 3 days from the date of receipt of the copy of this order. So ultimately he remanded back to the assessing officer itself. My only prayer is let this matter be also remanded back so that it can be decided on the basis of the papers and documents. And even if it is, because opportunity of hearing was admittedly not given.
You see, the wrong decision does not make it an order without jurisdiction. A decision of the assessing authority may be wrong on appreciation of facts, application of law. But that doesn't mean that it is an order without jurisdiction. Here, a requirement of a show cause notice, your reply, consideration of the reply, rightly or wrongly, whatever it is. All these things have ultimately ended up in imposition of penalty and interest upon you, and your ITC has been disallowed. These things can be looked into by the appellate authority. We are time and again saying that. We are not going to look into your invoice to see whether then we will be doing the job of a merit-based review, finding out whether the invoice actually corresponds to the same period and whether the tax was actually paid or not, etc. These are jobs of the appellate authority. 10% amount is to be deposited. Deposit it and avail it. The moment you deposit it, there is an automatic stay also of any recovery. So that's our view, I think.
My humble contention, Your Lordship, subject to your view, I'm just doing my job, Your Lordship, that they have actually not passed a reasoner. They are just stating that we are unable to satisfy for some. So they have to come to a certain decision, Your Lordship.
at least what is infirmity is to be looked into by the appellate authority. Na? Otherwise, the writ court would be examining all contentions on merits based on facts, invoices, etc., and undertaking the job of an appellate authority.
I completely understand your lordship because there is no
And
such
we have
allegation of
interest
presenting any false
to,
document or something.
we understand that the need for interference would have arisen if there was no show cause notice, if the show cause notice was vague, if there was no opportunity to give you a reply, or the order was without jurisdiction. So these are the things which we could get into examination in the writ jurisdiction or judicial review. All that has been done. He may have done it wrongly. Let the appellate authority examine all your contentions. And I think the limitation period is also already extended by the orders of the Supreme Court.
Yes, limitation is there till 28th of February as per the Supreme Court order, your lordship, as it has been extended. The order has been passed.
Avail that remedy.
Let my argument be entire because this is not the one incident, your lordship. I have filed at least 10 number of cases. So let my argument be there completely, your lordship, and then it may be given opportunity to avail my.
If we are not willing to entertain the writ petition on the plea of alternative remedy, then if you ask us to record your argument, our mind would also be opened. That would ultimately prejudice your case. It is not that only your argument will be written in the order. Mr. Mittal's argument would be there. And then we will say that yes, he has applied his mind, he has gone through the show cause notice. We are not inclined to interfere in the matter because it's not an appellate forum where all these facts can be looked into. We will simply say that this is under challenge pursuant to a show cause notice, and the respondents have taken a plea of alternative remedy under section 107. Rightly so. You avail of the remedy, withdraw the writ petition. We will give you that liberty subject to all permissible condonation of limitation, etc., which you can rely upon, invoke. Follow?
Your lordship, my only prayer will be, your lordship, that till the time the appeal, 2 weeks or 1 week, whatever the time may be given to us for filing the appeal, but in the meantime, my credit ledger may not be blocked into, your lordship, or my account may not be freeze for that particular moment. And when we will be filing our appeal, then 10% deposit has to be there because that is the mandatory thing which has to be done, your lordship. Only till that 1 week or 2 weeks time, only till that period only my credit.
I cannot agree to that, my lords, because this writ has been pending for a long time, my lords. The counter has been filed in August. Until now, rejoinder has not been filed. They can file, my lords. They can deposit 10% and they will obtain a stay.
So we are ready to deposit only for that particular time we are praying for. In the meantime, your lordship, 1 week time I'm also saying that within a week we will be filing it.
Ms. Amrita, the moment you file the appeal and pay that pre-deposit, there would be an automatic stay.
Yes, your lordship, but before that they are just even in a 1 day delay. They might.
My lords, their apprehension is misplaced. We could have done it even till now. There was no bar.
So all the writ petitions are identical in the challenge?
Yes, your lordship, all the four are identical in the matters, your lordship.
Yes.
सब में separate order करिए. 22 writ petition has been preferred with the following prayer. Counter affidavit. No, then counsel for the petitioner has pressed the challenge on the ground that the impugned order dated 28 September 2020, Annexure 9, has been passed without proper application of mind and doesn't contain any reasons for rejection of the reply slash explanation given by the petitioner as to the rightful availment of the input tax credit by them, supported by documents such as invoices, etc. Stop.
Their GST return and all.
GST returns, including the existence of registration in favor of the supplier, Messrs. Sai Enterprises, till it was
20.
cancelled on 29th January 21.
Yes, Your Lordship.
Then counsel for the, therefore the writ petition is maintainable and the impugned order deserves to be quashed. The matter needs to be remanded to the assessing authority to consider the explanation of the petitioner in with proper application of mind. Then counsel, the respondents have filed a counter affidavit. Then counsel for the respondent has contended that ITC availed by the petitioner against receipt of goods from a non-existent supplier, non-existent dealer, has been disallowed in view of the specific conditions, specific provisions of Section 16(2)(c) of the JGST Act 2017. Since, and stop, it is submitted that the assessing authority has, by a reasoned order, after proper application of mind, rejected the reply explanation furnished by the petitioner and disallowed the ITC availed by it for the period in question. Stop. Apart from that, then counsel for the petition respondent has taken a categorical plea of availability of alternative remedy of appeal under Section 107 of the JGST Act. Stop. It is submitted that the writ petition is therefore not maintainable. Stop. Ms. Amrita, you would like to withdraw or we would dismiss it on the ground?
Withdraw, Your Lordship, by giving a liberty to.
Then counsel for the petitioner then seeks liberty to withdraw this writ petition, seeks permission to withdraw the writ petition with a liberty to avail the alternative remedy of appeal. Stop. In view of the request made by learned counsel for the petitioner, liberty is granted, permission is granted to withdraw this appeal. Let it be made clear that we had not entered into the merits of the contentions of the parties. It is open for the petitioner to avail the alternative remedy of appeal as permissible in law. This petition is dismissed and withdrawn. 23 में
मतलब
23 is also same, your lordship. Only difference is with respect to supplier. In this, the supplier is Ma Kali.
सप्लायर का नाम माँ काली होगा और
Ma Kali Steel.
इन्फ्लूड ऑर्डर एनेक्सर 10 है 28/9/2020 माँ काली स्टील्स सेम पैरा 1 पोस्ट कर दीजिए
May I intervene, my lord? Item of 16 to 21, my lord. I am appealing for the board, my lord. For the JPN.
Mr. Roy, there are two more matters we are disposing it of. Then we'll come. 24 also you are appearing, Mr. Bhattal?
Yes, my lord. 24 I'm appealing.
Same order. What is the name of the supplier? Ma Kali Steel.
Ma Kali Steel, yes, your lordship.
Ma Kali Steel. Influed order is 28/9/2020, annexure 8. Item 25.
It is same, your lordship. Sai Enterprises is there. Sri Sai Enterprises.
Same order. Supplier is Sai Enterprises. And influed order is annexure 10, 28/9/2020.
Exactly identical are all the impugn orders, your lordship.
Yes. This actually is a problem. This actually is a problem where the supplier is not paying the tax and the recipient, even after having paid the tax, is not able to avail the ITC.
And we are suffering for that. And interest and penalty, on the other hand, is being imposed upon us.
There is a similar matter under the JVAT Act, which my lords have decided under Tarapur Company, my lords. That was a matter, my lords, that was decided under the JVAT Act. And this is...
There is one matter pending of that Maithan Power Private Limited with Odisha. I think Mr. Mehta was appearing in those batch of cases. Odisha High Court has given a stay.
Patron
Same situation.
The patron matters, my lords. Patron code. Yes.
Maithan Power.
My lords, I just sent one judgment, my lords, yesterday of the Supreme Court, my lords, where they've decided the issue of alternate remedy under 107 of the GST Act, my lords. If my lords would like to refer to that. 2021 SCC Online SC 884. Paras 11 to 13. They said that under GST Act, you should avail the alternate remedy under section 107.
That is always there. But one thing the department should also keep in mind that they should not be passing an ex parte order, your lordship. At least proper and sufficient opportunity should always be given.
No, this can't be called an ex parte
order. It's not ex parte order. It might be not non-reasoned or complete reason is not there.
इसमें उनके तरफ से वो लिख लीजिएगा. The counsel for the respondent has relied upon a recent judgment of the Apex Court in the case of Assistant Commissioner of State Tax and Others versus Commercial Steel Limited, 2021 SCC Online Supreme Court 884.
Paras 11 to 13, my lords.
In support of the proposition that in such matter, the SSC is required to avail the alternative remedy of appeal Para 10 to
11 to 13, Malad. 11 to 13.
11 to 13. Top. The exceptional circumstances in which writ petition can be maintained under Article 226 of the Constitution of India has been enumerated under Para 11 of the judgment. Namely, a breach of fundamental rights, semicolon, 2, a violation of principles of natural justice, semicolon, 3, an excess of jurisdiction, or 4, a challenge to the virus of the statute or delegated legislation.
Obliged.
Yes. Pass over my item.
Parcel of case, item number 3 to 21.
My lord, sorry, my lord, I could not appear the first instance, my lord. I am extremely sorry for the inconvenience, my lord.
You are appearing for JBBNL.
JBBNL, my lord.
इसमें लिख दीजिए आइटम 16 to 21 में counter affidavit appearances. Please send your appearances and counsel for petitioners and respondents. Counter affidavit has been filed by the respondent state commercial taxes department. By the commercial taxes department. So, Mr. M.K. Roy appears for the Jharkhand Vidyut Vitran Nigam Limited, within bracket JBBNL, and prays for how much time?
4 weeks, my lord.
4 weeks is good. 3 weeks time to file counter affidavit in all these matters. Stop. Time as pray for is allowed. Petitioner, if so advised, may file reply thereto within 1 week thereafter. These matters be listed after 4 weeks under admission. Heading admission. Let the name of Mr. M.K. Roy appear in the cause list henceforth on behalf of the respondent JBBNL.
May I request, my lord, the entire full name may be given, my lord, Mrinal Kantija, because it.
Mrinal Kantija. Mrinal Kantija. So, a name of others should be deleted.
Yes,
Ajit Kumar.
Yes, sir.
Name of Mr. Ajit Kumar and Mr. Manoj Tandon be deleted from the class list.
स्टेट की तरफ से एडवोकेट जनरल राजीव रंजन नेम शुड बी अपीयर ऑन बिहाफ ऑफ स्टेट.
The Advocate General appear in the cause list on behalf of the state. Yes, next.
For admission, item number 26, first appeal number 49 to 2019, Mr. Sanjeev Sinha for the appellant, Mr. Kaushik Sarkar for the.
But I am appearing on behalf of the appellant, Your Lordship. Yes, Your Lordship, the matter has not been withdrawn because the similar, as per the settlement agreement, Your Lordship, both the parties have to withdraw their respective cases. But due to the COVID pandemic, Your Lordship, the same has not been withdrawn by the parties. So I am praying that 4 weeks' time may be granted so that they may withdraw the respective cases, Your Lordship.
Other side?
Yes, Lordship, I am appearing. Because in the meantime, we'll also take the instruction of Lordship. Maybe time may be granted.
Respondent also has to withdraw certain cases.
Yes, Your Lordship. It is there in the settlement agreement, Your Lordship, para 2. Cases filed by the appellant and the cases filed by the respondent wife.
Then counsel for the parties pray for further 4 weeks time to take steps for to take steps for withdrawal of the cases instituted by the parties against each other, which is a precondition of which is a condition of their arrived at in their settlement during mediation. So, it appears that earlier on 3rd January 2022, on the request of learned counsel for the parties, 4 weeks time was allowed for the said purpose. However, due to prevailing COVID situation, further 4 weeks time is allowed to them to comply with the conditions of withdrawal of their respective cases, withdrawal/disposal of the respective cases instituted against each other, as a condition of their as per the settlement. List it after 4 weeks.
Obliged, Your Worship.
Item 27. Double case number 7311 of 2019, Mr. Sasi Kumar Baru or the petitioner, Mr. Rajesh Sinha or the respondent.
इसमें टेक्निकली तो ऐसा था बालक एप्लीकेशन में लगता
सेल भी कोई रिट किया था।
हाँ वो इसको सॉरी फॉर
Yes, who appears for the respondent sale, Mr. Chitresh?
Milaj, I appear for the respondent sale, Milaj.
So what happened to the?
Milaj, the other matter has been mentioned. The other matter has been mentioned from the office of Mr. Shresh Gautam, Milaj, and he's mentioned it again today, Milaj. That is my information, Milaj. I have spoken to him, Milaj, several times. He has said that he has mentioned the case on 7th of January, and perhaps he is mentioning it today again, Milaj.
It is restoration would lie before which DB?
Milaj, before this honorable court only, Milaj, he has mentioned, Milaj, and he has informed.
Bench of which I am or both of us are members, or?
It's not this DB, Milaj. There's some other DB. But my lodge is there in that division bench also, Milaj, with some other honorable judge.
It has not been mentioned before us today. For January 22, we adjourn it, making it that if he fails to do so, the matter will be heard on its own merit on the next day. CMP has been filed.
Yes, Milaj, it has been filed, Milaj.
You find out the exact details and tell us so that if we adjourn it, there has to be some genuine good reason now. You tell us which bench. If it is one in which I am also a member, I will ask the court master to list it.
Milaj, just pass it over for a few cases. Milaj, I'll ask Mr. Shresh Gautam to connect, Milaj, and email the price.
You ask him to join you.
Yes, Milaj.
Join. Pass over.
Item 28, contempt civil 3 356 of 2020, along with item number 21, 29. Mr. Vivek Kumar Patra, please.
My lord, I'm appearing in this case, my lord, on behalf of the petitioners, my lord. My lord, it's a contempt matter. My lord, order number 3, order dated 19/3/2021 may kindly be seen. My lord, though the state was granted, my lord, 4 weeks time to file the so-called reply, but my lord, almost about a year is going to be passed by, but no so-called has been filed. But my lord, substantial changes.
Wrongly listed हो गया है। Justice Mukhopadhyay and
Not wrongly listed in view of the fact that the division bench order, my lord, which I am seeking compliance of, my lord, Honorable Mr. Justice Sri Deepak Roshan sir was one of a party to that order, my lord, of which I am seeking compliance of. Lord, so order, it's a judgment dated 29/1/2020. Lord, that
no,
division
that we
bench.
understand. There is an order of assignment by Honorable the Chief Justice of 7 December 21. The matters have been assigned to a bench of Justice Rangan Mukhopadhyay and Justice Brother Justice Deepak Roshan.
My lord, I am sorry, my lord. Then I didn't know about it. That is the reason why I mentioned this matter before this honorable. Lord, I will be mentioning therein, my lord.
So we will indicate it today.
My
The
lord, my
matter
lord.
appears wrongly listed before us. In view of the order of assignment dated 7 December 2021.
If this court, my lord, may fix a date also.
No, that we can't. Let it be.
In view of the fact that substantial change has taken place in this case, my lord. Not very substantial changes. If any date.
Whatever it is, at least I cannot apply my mind.
My lord, my lord. Lord, the parties are nearer to coffin, my lord. The 70 years, my lord, 75 years old, areas of salaries matters is there, my lord. That is why, my lord, I pray this honorable court with folded hands, my lord. If any
You
date.
see, I am sure there is consent of brother to get it listed as early as possible. You just take the consent of the brother Justice Mukhopadhyay and give the
My lord,
slip
my lord, my lord. I will.
on the tied-up day.
My lord.
Appearing for the respondent parties, my lords. That can be done, your lordships.
Give your slip. AG1 के ऑफिस respondent. 27 में Mr. Gautam has appeared.
Yes, Your Lordship. Lordship, I'm appearing, Your Lordship, in this. Lordship, CMP has been filed, Your Lordship. I just had a talk with Mr. Chitresh. Lordship, CMP has been filed, Your Lordship. It was mentioned immediately before another bench, Your Lordship. It should have been mentioned before, Your Lordship, but somehow it was mentioned before some another bench.
So it was dismissed by a bench of?
Your Lordship and Justice Anubha Rawat, Your Lordship. Honorable Justice Anubha Rawat.
So my consent is there. You give the slip whenever. आप हमसे पूछ लीजिएगा ये कमेंट्स बनेगा उसमें ठीक है आप स्लिप दे दीजिए कोर्ट में
Yes, Your Lordship. Today itself, Your Lordship. Right now, I'll be sending it, Your Lordship. Obliged.
So Mr. Thresh Gautam, who has preferred the CMP number
149 of 2021, Your Lordship.
2021 for restoration of WPS number उस पिछले ऑर्डर में लिखा हुआ है submits that diligent steps are being taken for listing of the CMP before the appropriate bench for restoration of WPS number so and so. So, Mr. P.S. Chitresh, then counsel appearing for respondent sale in the present writ petition prays for an indulgence so that the both the writ petitions can be heard together. Stop. As such, let the matter of here in the week of 21st February. Stop.
Lordship, I'll just be mentioning it right now, Your Lordship.
Item 30. LK 2021, Shashank Sekhar for the appellant. Mr.
May I
Rajesh.
please, my lord? My lord, may kindly have, my lord, the last order, my lord.
So state was supposed to reply.
Yes, my lord.
Mr. Dubey, you
In this case, Your Lordship, I am appearing on behalf of the state, Your Lordship. As per Your Lordship, there is a rule to prescribe Your Lordship appeal, because on that very ground, on the basis of alternative remedy, it was dismissed, Your Lordship. So they have alternative remedy as per the rule, Your Lordship. Kindly see the rule 1951, Your Lordship, for a moment. Bihar Land Reform Rules 1951. 4B, there was prescribed the authority, Your Lordship.
have you read the Land Reforms Act?
I have read Your Lordship section.
Have you read our previous?
Yes, my lord, I have read our previous order, Your Lordship. I have gone through.
4B बोल रहे हैं.
4BS, Your Lordship, बिहार लैंड रिफॉर्म रूल्स 1951 है. इसमें ऑथोरिटी प्रिस्क्राइब हुआ है कि कौन कौन जो पेज यदि बिहार लैंड मैनुअल है जो, तो पेज 121 है. Appellate authority under proviso of section 4CC, the first proviso of section 4H, and the proviso of section 4HH. An appeal, Lordship may got it?
Yes, yes.
An appeal against an order of the collector under the proviso of clause CC of section 4, the first proviso of clause H. So I am concerned from H, Your Lordship, of section 4. Then authority B, Your Lordship, second, if such order passed by the collector of the district to the commissioner of the division, appeal shall lie, Your Lordship. But
yes.
So there is on that very submission writ was dismissal, because there is alternative remedy without exhausting. They have come in direct under 226, Your Lordship. That was my submission before the learned single judge, Your Lordship.
Indicated in the impugned judgment, no? So therefore
Provision, yes, provision they have not mentioned, Your Lordship, but there is a provision and authority also prescribed, Your Lordship. I specific for HH, they have also a rule prescribed in under which provision appeal is live. CC, H and HH. Only three appeal is prescribed. If below the rank of the collector, then appeal will lie to the collector. If collector pass the order, then to the commissioner, Your Lordship.
Yes, Mr. Shashank.
Lord, I have looked, my lord, the issue, my lord, which have been answered, my lord, by the my lord state, my lord. But my lord, with respect to my lord, the authorities which have been relied, my lord, they specifically state the LRDC cannot recommend, my lord. It's an adjudicatory authority. Therefore, my lord, the LRDC only, my lord, should have passed the final order under section 4H, my lord. Moreover, my lord, when the Jamabandi was created, my lord, since 1956, I am paying rent, my lord, regularly without any fail till 2021. Lord, this yes.
Mr. Shashank, on the last day,
yes,
on the basis of your submission, we gathered an impression that since the appellate authority is the collector, you are devoid of any remedy of appeal.
Yes.
Now, under the rules against the order of collector deputy commissioner under section 4 is the commissioner is the appellate authority, then you are not remediless.
Yes,
If
my lord.
only you were remediless, then we would have entertained it under writ jurisdiction or the.
That's true, my lord.
Yes, that was my submission before the learned single judge also.
Lord, I'm thankful, my lord. I have also, my lord, gone for the first time, my lord. I have also seen this rules provision, my lord. I'm not aware basically earlier, my lord.
You are not appearing in late court.
No, I have appearing, Your Lordship. I have given submission only under. I will not disclose the rule, Your Lordship. Due to.
You were appearing before the writ court, Mr. Shashank.
Yes, my lord. I was.
Yes, yes, both.
I
Both
was
of you were
appearing.
appearing.
Yes, my lord.
भूल गए क्या वहाँ क्या प्लेस हुआ था?
Lord, I did not, my lord, I did not peruse, my lord, the provision, my lord, 4B, my lord, before filing of the this LPA, my lord. I'm sorry, my lord, that
So,
for.
you want
हम भी पूरा
for your benefit, we will refer to 4B, Rule 4B in
Yes,
our
my lord.
order and ask you to avail of that remedy.
My lord, I will, my lord.
Third level counsel for the petitioner, Mr. Shashank Sekar and Mr. Mohan Dubey, AC2DG. Stop. The impugned order, the impugned judgment passed by the writ court reads as under. ये पूरा quote कर दीजिएगा इसमें पेज का 116-17. Stop. Then counsel for the petitioner, appellant, the petitioner slash appellant has argued about the has questioned the impugned judgment last on the following counts. यहाँ से इसको कोट कर दीजिएगा लास्ट देखे he relies upon section 2E etc करके ये फर्स्ट पैराग्राफ का लास्ट. Then counsel for the state has straightaway referred to Rule 4 capital B of the Bihar Land Reforms Rules 1951 inserted by notification number GSR 190 November 1972, which reads as under. Stop. He submits that the rules provide that if the order has been passed by the collector of the district, the appeal would lie before the commissioner of the division. The writ court, the honorable single judge, had therefore relegated the petitioner to avail of the appellate remedy. Stop. As such, the appeal is not fit to be entertained. You withdraw, Mr. Counsel.
My lord, I may be, my lord, the LP may be withdrawn with a liberty to prefer an appeal, my lord.
And counsel for the appellant therefore seeks permission to withdraw this appeal in order to avail of the appellate remedy for the commissioner of the division against the order dated 8th January 21, Annexure 16, passed by the district. The petition is dismissed as withdrawn. It is open for the petitioner to avail the appellate remedy as is permissible in law.
Deeply obliged, my lord, my lord. I was not aware of 4B, my lord. I'm sorry, my lord, for that, my lord.
Much obliged.
Obliged.
No, that very the read court I have only say alternative remedy. I have not read out the rule due to that reason. That was not quoted. Sorry.
Obliged to you, Mr. Dubey. You have informed.
No, Your Lordship, it is my duty. I have pleasure, Your Lordship.
I'm sorry once again, my lord.
Yesterday, Advocate General asked me, Your Lordship, you have given submission. Where is the provision? Then I have Your Lordship gone to give. No.
It's better to quote the provision and the submission so that nothing is left to speculation.
Yes, much obliged.
Obliged.
Much obliged.
My lord, in this case, my lord, they have not complied the order of this honorable court till date, my lord. But they have filed pursuant to the order of this honorable court for filing so cause. They have filed so cause. That so cause on 10th was not on record. Now, hopefully, my lord, it is on the.
What had happened, earlier, we have issued a reason. Earlier, a show cause was issued, that was withdrawn. Then after consultation.
Unmute yourself, Mr. Chitresh.
Sorry, Milord. Because earlier a show cause was issued by the department, Milord. That was withdrawn after consultation with the Advocate General, Milord. Now a fresh show cause has been issued, Milord, and they have replied to the same, Milord. And the department is in the process of taking a decision on the same, Milord.
Lord, I may be permitted to place, my lord, both the so calls, my lord. If my lord, they have filed both the so calls along with their so calls, my lord.
The other so cause is not before us, no?
Yes, my lord. That is, my lord, only one so cause they have filed, my lord, in this case.
So they have withdrawn.
On this 5th of January 2022. And I issued 2 to my.
This so cause has been withdrawn by you, Mr. Chitresh.
My lord?
Is this the so cause which has been withdrawn and then another so cause has been issued?
No, this is a fresh show cause, my lord. 5th.
A fresh so cause.
My lord, what they are submitting, my lord, the so cause filed before this honorable court, they have annexed 2 so cause notices issued to the petitioner. So first so cause notice they have withdrawn, and subsequently they have issued on the same line second so cause notice. And that so cause notice was given to on 5th of January. We have immediately replied, but till date they have not taken any decision.
I have spoken to the department, Milord. They are in the verge of taking a final decision, Milord. It will be taken up very soon. A final decision will be taken up very soon.
May I place, my lord?
His reply is under consideration, Milord, and it will be taken in the
His
shortest
so
possible
cause
time.
itself is against the spirit of the order of this honorable court.
Mr. State Counsel, the order was passed in the 17th August 21 in the writ petition. And
Milord, one indulgence may be granted, Milord. I have spoken to the department again, Milord. They are contemplating, Milord, a decision, Milord, and they will arrive to a decision, Milord, in the shortest possible time, Milord. A reply has been received on the month of January, Milord, and एक intelligence दिया जाए, Milord, will come up with a final order.
both the so cause are in the same terms.
Yes, my lord. That is only few words have been deleted in. And moreover, my lord, if my lord permits me, my lord, I am just placing before your lordship, my lord, before the writ court, my lord has passed the order that the petitioner himself is not responsible for such a long delay in taking decision for
opening the shop of the instead of reducing the fine and duty part, my lord, they have increased it. Even my lord, they have not renewed my license for the subsequent.
My lord.
You must have read the order. Your officers must have read the order.
Because we have advised them, Milas, they are considering Milas, and as far as my information goes, Milas, they will come to arrive to a Milas, a decision which is in consonance with the order passed by this honorable court, Milas.
But your show cause doesn't.
Because that is the reason why Milas, we had appointed Milas to them Milas to withdraw the earlier show cause Milas and file a fresh Milas. And Milas, they are in contact with us Milas, and
even if you have withdrawn the show cause, on the same, and moreover in para 8 on the page 19, the court had a finding that laid down a clear finding from the sequence of dates noted above. It is apparent that after receipt of chemical analyst Patna report on 15th October 20, till enhanced security fee was imposed on 29 January, petitioner was not responsible for the delay. And you are asking him to explain as to why this penalty be not realized from him for the said delay, same delay.
And moreover, my lord, they have increased that amount of penalty for this period also, which they have not taken any decision.
Please wait, Mr. Prabhat.
And one more thing, my lord, the manner in which they are harassing the petitioner, they have sealed my premises under the Excise Act, my lord. They have cancelled my license. They have not made an inventory and taken the entire exciseable article in their possession. They have kept the entire article in the shop itself, which is sealed, my lord. I have to pay every month rent for that shop, which has been sealed illegally till date, my lord, by the respondent.
Have you replied to their show cause?
Yes, sir, immediately. Immediately, my lord.
his reply, Milas, and we will come to a final order.
But the tenor of your show cause, Mr. Chitresh, does not seem to be in line with the finding rendered by the writ court.
Because I assure your lordship Milas, that the final order will be in consonance with the sentiments of this honorable court Milas, and the observations of this honorable court in its order Milas. We are in consultation with the learned advocates in the Milas.
You can tell your officers to be mindful of the purport of the order and the consequences if they tend to defy the order.
Milas.
Now, my lord, we are in the month of February, and the period of my that entire period is going to expire on 31st of March. My beer, which has been sealed, my lord, that has already expired. We have to wash, my lord.
You can be list from कंटेंट में भी टाइड अप का कंसेप्ट है ना
टाइड अप का कंसेप्ट नहीं लेकिन
अच्छा वन ऑफ क्योंकि दूसरे वाले में तो फिर वो साइन हो गया
अच्छा साइन था ना
देखा
एक प्रॉब्लम हो जाता है ऑफिसर्स का they go through this total fine
तो अभी हम लोग उसके बारे में नहीं बोलते हैं, आप बेंच बनेगा तो फिर से करवा दीजिए. Mr. Piyush Chitresh prays for short time to file supplementary show cause. Matter be listed in the week of 28th February.
My lord, if my lord may list this matter, my lord, seeing the urgency, my lord, because the period of is going to expire on 31st of March, my lord.
28 फरवरी वाले डेट में लिस्ट किए हैं, वीक में लिस्ट हो जाएगा. Yeah. kind of bench बना दीजिए. 21st फरवरी के वीक में रहेगा मिस्टर चित्रेश. आप
ठीक है बोला था, फाइल करवा दें.
Okay.
And ask them to understand the order. They only see the last portion of the order.
Well,
Pass a reasoned order, they only see that line. But the finding is.
it should be in consonance with the paragraph 19 of the order.
Para 8 of the order.
No.
Already, item 32, WPT number 747 of 2012, Mr. Jharkhand for the petitioner, Mr. Satish Kumar, Mr. Ajit Kumar Singh for the.
May please your lordship. In this case, Lord, I have prayed for an adjournment. Lord, I have sent a mail yesterday. Lord. This is a hearing matter, Lord. Earlier also petitioner has approached before this honorable court in the year 2012, and a reasoned order has been passed reiterating the same demand, Lord. They have insisted to the petitioner to register and pay tax the heavy earth moving machinery, Lord, working in the mines. So there are some developments, Lord, which I need to brought before this honorable court, Lord. Union of India has issued notification, not mandatory, but Lord, indirective in nature, Lord, to the state governments. And several orders has been passed by coordinate bench on single bench, Lord, or in
As
one matter.
counsel for the petitioner, that the matter is adjourned for 4 weeks. Please take immediately thereafter.
Obliged.
Lord, may I mention, my lord, one case, my lord, at item number 28 and 29, my lord.
That matter will go before the
My lord,
bench.
my friend, my lord, has given me an instruction, my lord, that the writ petition from which this LPA has emanated, my lord, was heard by Honorable Mr. Justice Sri Rangan Mukhopadhyay ji, and after assignment of this case before his lordship, my lord, he has perhaps seen the matter and has expressed his desire not to hear this matter because he was the presiding officer in a writ petition. And perhaps thereafter, my lord, this matter has been assigned before this honorable court. My lord, this is the instruction given to my friend by the office itself.
देखते हैं जरा फाइल देख लेंगे.
My lord, I was not properly.
डीयू तो आपके पास बना नहीं होगा कि कोई डीयू नहीं.
Lord, the writ was heard by his lordship.
No, so then once the matter is listed as per assignment before the bench of Honorable Justice Mukhopadhyay and Brother Justice Roshan, then maybe Brother Justice Mukhopadhyay will express that view and recuse himself, and then again it will go before another bench. समझ गए?
Okay, my lord. Perhaps, my lord, he has gone through this brief, my lord, in a chamber. I don't know, my lord, as my friend has said so, my lord. I don't know, I have not gone through the brief. Okay, Lord, I will mentioning there.
Last order है वही ठीक है. उसके बाद if the honorable judge doesn't want to hear it for some good reason, then it will get listed before another bench.
My lord, I have understood, my lord. Sorry for the inconvenience.
Very well.
My lord.
Thank you.